As an expert, regardless of whether you work for the plaintiff or the defendant, your key role is to educate your attorney-client in any technical elements of the case. This includes known technical facts in the case, plus newly discovered information of any technical nature. These ongoing discoveries may come from research that you perform, additional documentation from the other side, or just miscellaneous discovery by you or your attorney during the discovery process. Your attorney will often ask you to help by reading information submitted from the other expert and then analyzing its content. The hat you put on them may change according to the phase of the case and the side that retains you. Let's take a look at that hat when you are an expert witness for the plaintiff. The expert that works for the plaintiff has to do the appropriate research, analysis, or investigations that lead to believable findings and defensible opinions. Early in the case, your attorney may ask you to report your preliminary observations or findings verbally. He may also ask you to write a simple declaration or affidavit that addresses a limited technical portion of the case. Only after you have completed your investigation and analyses might this attorney ask you to write an expert report that contains your complete findings. By the way, if your attorney asks you for your opinions early in the case, you should make sure that you state clearly that the opinions you've expressed orally at this moment are preliminary. You should not hesitate to say that you have not completed your investigation or your analyses. You don't want to mislead your own attorney, but you also do not want to lock yourself into a position that you haven't yet firmly taken. You don't want to end up having to defend that position to your own attorney or his client. If you are the plaintiff's expert, the opinions in your expert report are central to your work and often to their case. The attorney for the plaintiff wants to offer them to support his case. First, don't stretch the truth, and don't offer an opinion or conclusion that you can't back up completely by your research and analysis. Don't permit your attorney to pressure you into expressing an opinion that you do not fully believe and cannot fully defend by what you know as the expert. The investigative procedures and analyses that you include in your expert report should stand as a foundation for those opinions. By the way, you should be careful not to let your phraseology make your opinion harder to defend. For example, do not claim in your report that something is always true or is never true, even if you do not currently recognize any possible exceptions. My humorous tactic that I would say to you is never say never, and always avoid always in your opinions. Let's take a look at some of these questions as an expert witness for the defense now. The expert for the defense has the task of reading the plaintiff's expert's findings or reports or affidavits or declarations. If you are that defendant's expert, your goal should be to look for factual errors and any oversights or mistaken assumptions by the other expert. You should assess if the other expert's research, study, procedures, or references do not fully support the opinions that he or she has expressed. Your lawyer client will use your assessment of the other expert in case planning and perhaps future questioning. What's his goal? The defense counsel generally looks for information that he can use to discredit the plaintiff's expert. He wants to cast doubt on the expert's facts or methodologies, if possible, and as a jackpot, he'd love to actually negate some or all of the other expert's conclusions through your study and analysis. The defendant's experts must look at every opinion expressed in the plaintiff's expert's report. First, see if each opinion makes sense to you as an expert in your field. If it does make sense, fine. You can still go further and verify whether the plaintiff's expert has adequately explained the procedures, or science that led to his opinion. If you can find any weakness in his logic, even though he has drawn technically correct conclusions, you should point that out to your attorney. Further, you will probably want to point out such logical weaknesses in your own rebuttal report, which you will probably prepare as a direct response to the plaintiff's expert's report. Perhaps an opinion in the expert's report strikes you as incorrect or weak. You should explain to your attorney why you believe this, and then include it in your own rebuttal report. Whatever you write in this rebuttal report will become the subject of your own testimony for the defense.